Good morning, WTOB listeners. This is Dylan Greenwood along with Harold Eustache. We're here to present to you For the Record with Greenwood Law this morning here on WTOB. And this morning we're going to be talking about animals and pets and their relationship with the law, your relationship with animals and pets as a human being, and all the different ways that can intersect with the law and potentially bring out liability. Reason why we thought this would be a good topic to talk about is there's been a pretty infamous case that's hit the news here recently in Forsyth County where an individual was accused of being quite cruel, if those allegations are proved beyond a reasonable doubt, taking squirrels, possums, and doing all sorts of things to them.
Burning them, drowning them, stuff.
All that and more, and then videotaping it and putting it on the internet. That's just one way in which somebody can have some liability here. And in fact, there can be not only state consequences, but there can be federal consequences for things that happen with cruelty to animals or with animal fighting. Just think back to Michael Vick and his convictions. I know that I'm a graduate of Virginia Tech, so that was something that I followed quite closely. And he spent some time in federal custody for that. So we're going to go over all the different things involving cruelty, fighting, how you can be liable for certain things, what penalties are involved, and there's really a lot to unfurl here because you hate to see cases like this, but we have them from time to time here, and personally, I know you've prosecuted these cases. I've defended many of these cases. Some of them have been as disturbing as this that we've been talking about, but I've also I've had them where my client didn't necessarily realize that what they could have been doing might have been construed to be cruelty.
I think that's an important part of this that we want our viewers to understand. So the way there's numerous statutes, there's a sort of a part of the code that deals with animal cruelty in North Carolina. And it's really broken down into misdemeanor cruelty and felony cruelty. And the way to think about the difference between the two is the state of the mind of the person that is being cruel. And a lot of times people, as Dylan said, people don't necessarily recognize that what they're doing is cruel. So the difference between misdemeanor and felony is the misdemeanor is intentional. And so the way that the law basically says that the person was aware or conscious of what he or she was doing, and there's no justifiable cause. So it doesn't mean that you were necessarily wanting to torment your animal necessarily, but it could mean that there's no cause for what you're doing, and you knew that the thing you were doing is in fact what you were doing. What that means is, if you put a 50-pound pack on a 20-pound animal, and you had it run and had it running for a long way. Now you knew you did that. You may not have known what the consequences would be, but there's no justifiable excuse for it, and that could be construed as cruelty under this kind of statute. So there's numerous ways to do that. It could be tormenting or wounding an animal, but it can also be depriving an animal of the necessary sustenance, and that's one. It's actually, we see a lot, is where owners aren't properly feeding their animal, properly caring for their animal in that way, and that can be part of animal cruelty. The felony cruelty is when that cruelty becomes malicious, and that's a whole other part. But that's when the statute says that it's felonious cruelty there.
Yeah, there's an interesting distinction here, and one that I think most of us would say, well, that makes sense. If the way you can look at this is comparing it to human-on-human violence and versus human-on-animal interaction like this or violence. It's not always violence. Like we said, not providing sustenance, overdriving, overloading, those are all things that can be cruelty to an animal. But you can also, if you intentionally did it, you could kill an animal and it still be a misdemeanor.
Right.
It only becomes a felony when it is done maliciously. That's a big departure, and it makes sense that this is a departure from what happens between assaulting someone else, another human being. Generally, it's a misdemeanor. It can go up from there depending upon what happens, versus killing them. And if you intentionally kill somebody, if you've premeditated it in some way, obviously that's the top level. But even if your actions weren't necessarily intentionally done to kill somebody, but you were so negligent in doing so, that can still be a felony too.
Oh, yeah.
So it's not like we take that and parse it down to a misdemeanor like we have here with animal cruelty. So like Harold was talking about, the biggest distinction here is whether or not it is malicious. And that is not always easy to parse out because North Carolina statutes don't really define what is malicious. Mm-hmm. And in fact, it's really a case-by-case thing where you have to, a lot of times it does kind of follow this definition that we derive of what is malicious that we pull from a homicide law and how we define malicious there. So, that definitely is a difference. We're looking, is the act done with ill will, hatred, or spite? Is it an act that causes death that is inherently dangerous? Is it done so recklessly that it reflects a complete disregard for life or social duty? Is the act done intentionally and without justification or excuse? Which, if we're looking back at the example that we gave when we started this,
that's what I was thinking.
And you're talking about capturing woodland creatures and burning them. What's the justification there? What's a squirrel doing to you? Now, that could change if that squirrel was rabid.
Right.
And let's say that squirrel was rabid and the squirrel's coming for you. That changes the whole calculus.
It does. And so I know people's minds are going to, well, what if there's some dog or some bear or some animal that's putting me in danger or my family in danger? Do I have the right to kill that animal in self-defense? Well, yes, you do have the right to kill the animal in self-defense, but it's narrow in the way that the law looks at that. So one example is that is in an important case where the court said that it wasn't self-defense. And what happened was there were essentially two dogs fighting. The owner of one of the dogs broke the fight up and then shot the other dog after the fight was already broken up. And his defense was, well, I was defending my dog, and the court said, well, you broke the fight up. The dog wasn't a threat to either the owner or the other dog. These dogs were just sort of, neither dog was really the instigating dog. And so it was unlawful for him to shoot that dog. But if a dog was, or some other animal, any other animal was coming at you in a certain way, and there's no other way for you to get out of this but to kill that animal, then you would be justified in doing so. But it is narrow in the sense that I think the law wants to make sure people aren't just saying, well, the dog looked really crazy, so I put the dog down.
Right. And the important thing with what you're talking about there is you're protecting some other living entity. Mm-hmm. Now that becomes different when you're talking about property, mm-hmm. except for property as it's defined as your pet. And your pets, dogs, cats, birds, whatever, that is your personal property. That's mm-hmm. how it's considered in the law, and you're allowed to protect those things. So there's another case that came about where a farmer had a field of corn, and his neighbor's chickens liked the corn. Shocker, right? That these chickens would come over and like this corn. And so they kept pecking his crops. He didn't like it, so he killed the chickens. Well, that was unlawful. That was determined to be an act that violated the law. It was animal cruelty because he killed the chickens. They were not his chickens. He did not do so for the purpose of eating them. He did so retaliatory for what they did to his crops and to try to prevent further destruction of his crops. So, you would hope that he tried to talk to his neighbor before this happened and say, hey, keep your chickens off my corn. We don't know all those facts. But basically, he killed the chickens, and it was a violation of law because they said you can't protect property in this way. Now, if the chickens were coming after your small little puppy and you were worried about its safety, you could do something to the chicken. Mm-hmm. Or if you were able to successfully argue that the chicken was coming after you and you absolutely feared for your life somehow or another from a chicken, then, it's possible. You're going to have an uphill battle on that argument. But, that'd be one heck of a rooster coming after you. But, it can't be for personal property overall. But the felony version of this, it's a Class I felony. It's serious. Things that are inherently malicious that the law defines are as torture, mutilation, maiming, cruelly beating, disfiguring, poisoning, or killing. But the killing has to be malicious in nature, separate from intentionally doing so in the misdemeanor version. And I think all of those besides killing do denote some sort of extra step, some sort of enhanced level of activity that you've done to the animal to be cruel to it.
Right. And just like you mentioned with the defense issue, there are some other exceptions to these misdemeanor and felony cruelty laws, and they would be conducting sort of some authorized biomedical research, of course, for livestock, for human consumption or animal consumption, for veterinary purposes, or for protecting the public or other animals or public health are some of the reasons why there would be exceptions here.
Hunting as well.
Hunting, yes.
Yeah, don't forget hunting. So all of our hunters out there, if you have a valid hunting license, and you are hunting within your allotment that you're allowed to do, that is one of the exceptions to this.
Yes, it is.
And so that would not be considered a violation of the law. Right.
I think one other thing that I think it would be important for us to define is what an animal is, and we kind of had this discussion before.
Yeah, we did.
Before the show, and it's interesting in how North Carolina has progressed on what an animal is. Mm-hmm. Originally, it was any living thing. I mean, which is us and bugs and all sorts of stuff, and you can see how that would be an interesting way to define any animal and be fraught with all sorts of problems for the court system. But as time has gone on, they've revised that, I think.
Yeah, they've said, not human beings. Right. It's basically mammals, reptiles, birds, that sort of thing. And those are, more often than not, there are things that you would consider to be pets and or livestock.
Right.
That's the easiest way to think about it.
So the spider in your house is not animal cruelty.
Just burn the house down to the ground. That's always my approach for any type of spider. So just, that's fine. Not really. Don't burn your own house down.
I do wonder what the snakes would be considered, but that's maybe
snakes. That that is an interesting thing, especially
people have them for pets. And
it depends on what it is, I think. But you don't know until it gets applied.
Not a huge fan of them.
Yeah. But we alluded to it before. One of the other ways, and I think it, I think it embodies a lot of the spirit of cruelty laws, but it carves out its own separate law, are these fighting statutes. And there are 3 of them in North Carolina. One of them is cockfighting, the other is dog fighting, and then there's a generic animal fighting, which does that make sense given, our history, society, everything else. The first 2 have certainly been more common forms of, lack of a better term, sport,
right.
if you will. The other animal fighting, I would say, is not as common. So that's why I think there's been a specific law that's carved out for those entities. But it's a serious offense.
It really is, and believe it or not, these offenses certainly are charged. They do happen, and that they are taken very, very seriously by law enforcement, by the courts, and so on and so forth, and by the law itself. I mean, not only can you be charged for being the ringleader of cockfighting, but being involved in any sort of cog of cockfighting, including
promotion,
being a
breeding,
any of it. Yep.
Any of it, fashioning the tools or the gaffs that are needed.
If you profit from it.
Although it is unclear to some degree on gambling on it.
Sure.
That one is tenuous. It's unclear as to whether or not that's a true violation of the law, at least as it pertains to cockfighting, I think.
If you're a spectator.
Yeah, spectating. So
just by attending one of these fights and supporting it, you could be charged with a felony. So these are taken very seriously, and for obvious reasons, I'm sure our viewers understand. It's can be very detrimental to the animals, very harmful to the animals involved, and disfigure them in all sorts of ways, and really mentally and physically for these animals. So it is very, very frowned upon by the law, and something that is not only violate state law, but also can violate federal.
It absolutely violates federal. In fact, I was involved in one of these cases one time at the federal level. We actually had to get a rooster expert to come in and be willing to testify. And I learned more about roosters than I ever thought I would learn in preparation for that hearing. But, you at the federal level, you may wonder, we'll say, how in the world, does the federal government get involved in something like this? And that is a fair question, because I would say out of all the things that the feds do, which predominantly involves guns, drugs, and immigration, which are all things that typically affect commerce or cross state lines, well, how does cockfighting or any type of animal fighting work with that? Well, the hook is commerce, the commerce aspect of it, and all the violations that you see about animal fighting, or violations would be sponsoring or exhibiting the animals, transporting them, buying or selling them across state lines, using the mail for interstate commerce to promote the fight. So if you send out a flyer using the United States Postal Service that you're holding a big cockfighting exhibition somewhere,
not smart.
No, not smart at all. It doesn't matter if the mail did not leave your local township. It does not matter at all. You still use the United States Postal Service to do it. That's a violation of federal law. And then buying, selling, delivering, transporting any type of knife, gaff, or other sharp instrument to attach to an animal. Usually that's in cockfighting. I learned that. Usually that's in cockfighting, using like different types of knives and stuff on
the talons or
so those types of things would also be a violation of federal law.
Another one we were talking about that's interesting is a depiction of animal cruelty can be a violation of federal law. And this statute is, I've never seen it before today, and it's interesting because it has an exception to it, and it says so if you depict animal cruelty with the intention of placing the depiction in interstate or foreign commerce, it can be a violation of law. But it says the exception is any serious religious, political, scientific, educational, journalistic, historical, or artistic value. So I'm like, what other reasons would you be depicting? I mean, it's an interesting statute for sure.
So So if we're going back to the case that we're talking about at the beginning,
Yeah.
those depictions
That he sent.
I don't
Could
know.
be a federal, yeah.
Yeah, it could be a federal issue, for sure. Just joining us here on WTOB, it's For the Record with Greenwood Law. Dylan Greenwood here talking with Harold Eustache, and we've been talking about animal cruelty, laws involving, specifically criminal laws involving pets, livestock, and other animals. Brought on recently by a case where there were depictions of cruelty to animals that were cast out over the internet, and there's possible federal implications because of that, and all sorts of issues that individual is going to be facing. But one of the most common ways in which a pet owner of any type of animal could run into issues with the law involves leashes. And there isn't really a like a broad North Carolina leash law. There are two sort of roundabout statewide laws that prohibit certain activities. One is which prohibits persons from allowing dogs to run at large at night. So that's one. And the other one prohibits female dogs from running around at large in heat. So both of those things are class 3 misdemeanors. They're violations of the law. But besides that, what you hear about from a leash law or a leash law violation isn't a statewide thing.
No, those are county ordinances, and those are, believe it or not, charged very, very frequently by law enforcement. A lot of calls that law enforcement get are with regard to pets. Pets being too loud, pets being unleashed, roaming the neighborhood. That is just a common thing that law enforcement sees. So if there's a pet owner that the dog or let's just say a dog is not leashed, is roaming free, that owner could be charged with an infraction called a leash law violation, and that is in violation of an ordinance, county or city ordinance that basically says that you have to keep your dog leashed or confined in some way at all times. So if you're walking with your dog, and you're just walking your dog without a leash, and I see it all the time, on different trails or whatever. It's not a big deal, but you could be charged with leash law violation. A lot of times in my experience, when I've seen people charged with it, is when officers get called more than once. Mm-hmm. There's a warning given, hey, put your dog on a leash. It keeps happening. That's when it can become a part of some sort of neighbor dispute, and you see it charged.
So while Harold's talking about leash laws as it relates to making sure that your dog is on a leash or confined in some way so it's not going on other people's property or running wild about and messing with people, there are laws the other way, where if you leash a dog for too long, or you leash a dog in a certain way, like on a cable tie system or a cable trolley system, and the dog cannot move very much, then that could be a violation of another type of leash law that also is an ordinance. It's an infraction, but depending upon the severity of it, could cross over into that animal cruelty territory. But again, that would have to really depend upon the severity, how long the animal was on that leash, that sort of thing.
It would, and one of the other things I'm thinking about, there's so many of these laws out here for I want our listeners to know that, and there's several that we kind of haven't even touched on. One of them is abandonment of animals. If it is a misdemeanor to sometimes people say, I want to get rid of this dog or cat and just throw them on the side of the road. It's awful to think about, but people do that. That is a misdemeanor to do that. In addition, it could be one of the interesting things, and we've talked about this a little bit before with actually children, but leaving them in a car.
Yeah.
That is something, especially it's hot right now during the summer. It is something, you're going in the store, but you know, a lot of people drive with their pets, and leaving your dog in the car for too long can be a violation that can be pretty serious. Yeah.
No, you're absolutely right. The last thing I want to touch on is one of the things I find most interesting, like an interesting little caveat in our law, are these larceny statutes.
Yeah.
There's a larceny statute specific for horses, mules, swine, and cattle. So for livestock, makes it a Class H felony for you to steal any of those pieces of livestock from somebody's property. There's also a subsection in that specific for dogs, that larceny of a dog is a Class I felony. There's no such exception that are carved out for cats or birds or any other thing is specific for dogs. So I think our legislature here in North Carolina is a bunch of dog lovers, has to be, to carve out that exception. Or the dog family pool and the they pound a very large, loud drum with their legislatures in North Carolina. So I do find that that's a interesting little caveat in our law.
WTOB listeners, thank you for joining us on For the Record with Greenwood Law today as we discussed various topics about animal cruelty and dogs, cats, and everything in between. We hope you got something out of that. Don't forget to join us next week on For the Record. We're going to tackle another important topic. But before we go, Dylan, the Bill writes.
You got it. First and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. It's not a crime to know your rights, know the law. It's a great idea to stay informed, but stay safe out there. This is For the Record with Greenwood Law, signing off.